We're here at Rosen Injury Law, and I'm here with our friend Diane Perez from Diane Perez, PA, and she is a labor and employment lawyer, and we're going to be talking about all things labor and employment, whether it's the plaintiff side representing the employee or the defendant side representing the employer. So I'm thrilled to have you here. Introduce yourself and tell everyone a little bit about your practice.
Thanks so much for having me. I am a board-certified labor and employment lawyer here in the state of Florida. I represent employees and employers in litigation, advising, counseling, contract review or preparation in the employment arena.
So tell everyone just a little bit from the employer perspective, why is it important for an employer to hire a labor and employment lawyer like yourself?
Well, I always tell employers it's important in the very beginning of establishing their operations to make sure that they hire an employment lawyer and make sure that they have the proper policies in place and procedures because it saves a lot of headaches down the road from a litigation standpoint. It's important to be advised in terms of how to classify your employees, how to maintain records, how to properly document and conduct performance reviews and things of that nature. So I think it's a cost that's worth spending when a business is first starting up because it will avoid a lot of expenses down the road.
You know, I heard that a long time ago, and when I opened my business, I reached out to a labor and employment lawyer. You weren't around at the time. We didn't know each other. I would have reached out to you, but I thought it was important to at least get some advice on how to run a law firm, whether I need policies and procedures in place, systems in place. And so are those some of the things that you advise employers to do, is have a policy and procedure, human resources policies in place?
Yeah, I mean, from the very beginning, it's important to have those things. So for instance, if you're going to hire someone, you want to make sure your application is correctly drafted. You want to make sure you have an offer letter, a job description that provides what the requirements of that position are, because the law is very clear that if an employee needs a reasonable accommodation, the court is going to defer to the job description to determine whether there is the need for that accommodation. So job descriptions, employment handbooks, non-competes, confidentiality agreements, and then also just being able to conduct an audit of what the individuals that are working there do every day, how their compensation should be structured, and the documentation that should be kept, like pay and time records, personnel files, medical files, and things of that nature.
It sounds like you are obviously well-versed in all the different areas of employment law. You mentioned something about non-competes. What is a non-compete, and are they enforceable in Florida?
Non-competes are enforceable in Florida. There are requirements. It's governed by a statute. Florida, our courts, our laws, we like competition. Competition is good for the marketplace. But we'd recognize, obviously, that some employees are privy to confidential information and contacts with clients and customers and goodwill. So non-competes are enforceable if, one, there's a legitimate business interest that needs to be protected. So that employee has to be in a position that he or she would be privy to certain types of contact, let's say, or goodwill or specialized training. And then, obviously, the agreement itself has to be properly drafted. It has to be reasonable in time frame and geographic scope. But essentially, that contract will prevent an employee from competing or maybe even soliciting customers and clients for some period of time after the employment relationship ends.
And those could really be important, obviously, if an employee is unscrupulous and tries to take trade secrets, or if they try to take client names and start soliciting them, that could be there to protect the employer, right?
Yes, correct. It's a huge protection. Florida has a misappropriation of trade secret statute. So even in the absence of a non-compete, if there is a misappropriation of a trade secret, you could sue the employee for that. But the non-compete is important in that to the extent that there's confidential information that's being used, or that employee has received specialized training that you have provided him or her, it wouldn't be fair for him or her to now be able to use that at a competitor. So it is important, and I always advise employers that if they have a specific employee that they're concerned about, for instance, like their salespeople, right? Mm-hmm. I think it's worth considering rolling one out.
That's really, really interesting. And so tell me some of the pitfalls that you see employers go through with employees when they haven't prepared ahead of time.
So I always say, from a defense standpoint, when an employer gets sued and they contact me and I say, okay, what happened here? Oh, well, the employee had all of these performance issues. They were always a poor performer and we had to terminate him or her. And I always say, okay, well, send me the personnel file. and that personnel file is practically empty. I mean, there's an I-9, a W-4, but there aren't performance reviews that have been conducted. The counseling with regard to their performance is not in writing. Maybe I can get an email at some point, but when a personnel file gets to me that way, it makes it harder for me to defend a case, which is why I always advise clients that it's very important from the employer's standpoint to make sure that your documentation is adequate, that performance reviews are conducted, that counselings are provided in writing, so that in case you have to terminate that employee, you have the documentation to support the reason behind the termination.
So Florida, I heard, is an at-will employee state. What does that mean?
Well, right. So the at-will status essentially means that the employee can quit at whatever time and the employer can terminate him or her at whatever time, with or without notice, for reason or no reason. Obviously, the reason has to be lawful. It can be discrimination or retaliation or whistleblowing. But essentially, that means that either side can walk away from that relationship at any time, absent an employment contract for a term. So a contract that would state, we're going to employ you for 1 year and we can only terminate you for the following reasons, by way of example.
So just maybe explain to everyone, how is it that it comes up where an employee brings a lawsuit against the employer doesn't have enough documentation in the file that shows the reasons why they terminated the employee, but the employee is still able to bring that suit even if it's an at-will state?
So the employee would have to file a lawsuit, discrimination based on a protected class, or retaliation. Let's say that employee complains about unlawful conduct and now they've been fired, or whistleblowing, by way of example. That employee will file a lawsuit and will say, hey, most of these cases are circumstantial. There's very rarely direct evidence of discrimination, but that employee will say, look, I am African American and I engaged in this conduct, and a white person who engaged in the very same conduct was not terminated. Okay. That is that employee's burden of proof at that stage. Then it's up to the employer, who has a burden of production, not proof, to produce documents. No, it didn't have anything to do with the fact you were African American and had to do with your performance issues. And these are the documents that we have in that personnel file to show that. And then once the employer does that, the employee then has a burden to prove that the reason that's been given is not the real reason for the termination. But when I don't have those documents, it almost adds to the reason not being what the employer has claimed, because if it was performance, how come nothing has been documented? Well,
so then if you could tell all the employers in the state of Florida, one important thing to do as far as their personnel files, what would it be?
Performance reviews and write-ups. Performance reviews should be conducted every 6 months to a year. Obviously, employers get busy and it's hard for them to take the time to do that. They're busy running a business, but it's very important. So those performance reviews, and to the extent that an employee is not properly performing, to make sure it's documented in a written counseling that's placed in that personnel file.
Sounds like very, very good advice. So now let's switch over, because we've been talking about the employers and protecting the employer. Let's talk about employees. Tell us, what are some of the, are employees allowed to have overtime if they're a salaried employee?
So that's actually a misconception. Some salaried employees are not entitled to overtime if they fall into one of the exemptions under the federal law that governs overtime compensation. So if they're an administrative employee, an executive employee, and those words have specific meaning under the law. But there are some salaried employees that are still entitled to overtime. And so employers oftentimes think, well, if you're an employee who's salaried, I don't have to pay you that overtime because you're not hourly. And that's not necessarily true. You have to look at what that employee does every day and figure out if you can put them in an exemption before you make that determination.
So what are some of the common employee positions that you see that are salaried but are entitled to overtime?
So in the legal field,
Sure.
A lot of times I see it with paralegals, let's say. Not saying that generally paralegals are not exempt. It depends on those job duties and responsibilities. But I have found that a lot of paralegals are in fact entitled to overtime, even though they are salaried. Sometimes you can just have, let's say, a bookkeeper who is salaried at work. That bookkeeper is likely entitled to overtime compensation. Again, I'm just saying, more general, because it's going to depend on what that person does day in and day out. And the decisions aren't governed by the title of the position. But generally speaking, based on what a bookkeeper does, a bookkeeper would be paid overtime.
I was just thinking that from what I learned, I guess, as a young lawyer working at, a big law firm for a very long time, I learned very quickly that I was not entitled to overtime. Are lawyers entitled to overtime if they're a salaried employee?
No, there's an exemption for lawyers and doctors.
All right. Well, you heard it.
Professionals.
You heard it here. You are not getting overtime if you're a lawyer working at a firm as an associate.
So sad.
I know, it is too bad. It is too bad. So, if an employee feels that they are being taken advantage of and they are working that overtime and they're not recovering the compensation that they are entitled to, what should they do?
So the employee has two options. One, they can go to the Department of Labor, and the Department of Labor is the federal department, U.S. Department of Labor, and they can file a complaint, and the Department of Labor will then conduct an investigation into the pay practices of the employer and will then potentially award back pay to the employee. Or the employee has the option of filing a lawsuit under the Fair Labor Standards Act to try to recover that overtime.
Okay. And then if they do file a lawsuit under that act, what is the compensation, or what are the damage that they're entitled to?
So they would be entitled to overtime, the missing overtime compensation. Now, depending on how they have been paid, if they're hourly, it's time and a half. If they're salaried, it's a half-time rate. Okay. But they're entitled to that. And then they're potentially entitled to liquidated damages if the violation is willful, which is double damage.
Double damages.
Yes.
Okay. So let me ask you the question. So there are a lot of employees that may have the question, if they have accrued paid time off and then they're terminated, are they entitled to recover that paid time off money?
Employees oftentimes believe that they're entitled to pay time off, and they'll call me and they'll say, hey, I've been terminated. I had all this accrued unused PTO. And I explain that there is no statute or law in Florida that would provide that they are entitled to it. But if the employer has a policy or a practice of paying it out at the time of termination, or let's say there's a contract that says, hey, if we terminate you, you'll be entitled to the paid time off you didn't use, or even in an offer letter that say, then yes, it would be paid out. But without those, the employee is not entitled to the payment of PTO at the time of termination.
But so if an employee is terminated and they feel they are entitled to paid time off, should they at least reach out to an attorney like you to investigate to see if a contract or policy exists?
Yeah, I think it's worth doing that. I always advise that, if there's an HR department, that may be the first place that they want to go to just, contact them. Because the HR department will say, hey, we don't have a policy or practice, or yes, we do, and we've paid it out before. But yes, it's worth their time to just take a minute and call an employment lawyer and find out, what their rights are. And then we can kind of talk through whether there is a policy or practice if they know of somebody else who's had that paid time off paid out to them.
What are some of the other common things that you see where employees need a lawyer against their employer?
So usually I see it unpaid commissions and bonuses. That's a big one that comes up a lot, right? The issue of when the commission or the bonus is earned and when it should be paid. Usually at the time of termination, because let's say that the commission, whatever had to be done to earn that commission has already happened. They then get terminated, but it hasn't been paid out yet. They will call me about those issues. I get calls about severance pay oftentimes. Am I entitled to severance pay? Why am I not? I'd like some. That's a big question that comes up a lot with employees. And then obviously discrimination, retaliation, harassment in the workplace. And interesting enough, I get a lot of calls about hostile work environment. And I think that there's a misconception that employees think, somebody was being mean to me, or they've been mistreated me, or they screamed at me, or they bullied me. That's a hostile work environment that's actionable. Unfortunately, in Florida, we don't have an anti-bullying law for employees that would protect them. So that term hostile work environment has a definition under the law, and that's usually what we see in harassment type cases based on protected categories, race and gender and things of that nature.
For the most part, if an employee reaches out and let's say they haven't been paid their commission, their bonus, and they were terminated, or maybe they're working and the employer hasn't paid that bonus or commission, are you able to, in your experience, resolve those problems without filing a lawsuit?
Yes, oftentimes, yes. Oftentimes we can send a demand letter and we can get it resolved pre-suit. And I always advise that that's probably the first step, either through an attorney or even if they contact HR first. I think it's the most efficient process because in the employment arena, I'm sure it's the same in your
Yeah.
area. Litigation takes a very long time, and that employee wants the compensation now rather than 2 years from now.
And you also think of it like this, and I think it's employer and employee on both sides, is not everyone wants a lawsuit, right? You want to avoid a lawsuit. You don't want the stigma that can go along with it. You don't want to be an employee known that's constantly suing the employer. You don't want to be an employer that's getting constantly sued.
Yeah, correct. And that's like a big deal for employees. They'll call me and they'll say, hey, you know what? I'm concerned because I don't want this lawsuit coming up down the road if I go, apply for a new job. And it is a public record. Obviously, I can't promise them that it's not going to come out at some point. Obviously, employers are not allowed to retaliate against an employee who has asserted a discrimination right or a retaliation right against a former employer. That doesn't mean it doesn't happen. And there is that risk, obviously, associated with that public record.
Yeah, yeah. Well, I think the number one step is, like you said, get to human resources, try to resolve it without having to escalate it, but at least get the advice of counsel while you're doing that, right? I think that's an important thing too.
Yes, absolutely. And I tell employees, if you're still employed, the human resource department is the first step you've got to take, because what you don't want to do is end up leaving a company and going and filing a lawsuit and then somebody turning around, a defense attorney turning around and saying, well, you could have complained about it. The company had no idea.
Yeah.
You could have complained about it and you didn't. So that's always the first step. Go to human resources if you're still employed there. Obviously, once you're no longer employed, it's a little harder to have access to it. But if you're still employed, go there, complain, hey, I'm owed wages. I'm being harassed. I feel I'm being discriminated against. Take that first step. Let the company investigate it and figure out if there's something that needs to be fixed. And if at the end of the day, they don't fix it, okay, but you've done whatever you needed to do internally to try to get it resolved.
So Diane, how just tell everyone, how is it that an employee or employer can get in touch with you?
Sure. They can visit my website at www.dianeperezlaw.com, or they can email me at diane@dianeperezlaw.com.
And I think you have some social media out there. What's your social media handle so that people can reach out to you on Instagram or whatever other platform?
On Instagram, it's Diane Perez Law. I am on Facebook as well as Diane Perez PA.
All right, there you go. So listen, if you guys have any questions, anything about the issues as an employee or issues as an employer, reach out to Diane. She is here to help, here to give good counsel, good advice. And like I said, I'm super happy that you came here and we're able to create some of this information and give it out on social media.
Thanks so much for having me.
All right.